Well, welcome to Facing the Giants Trial Lawyer Roundtable Panelist Questions. We're here today with Steve Murray, Susan Klopman, and David Seserman to talk about their experience themselves and their experience facing the giant law firms. I'm going to turn it over to Sue. Will you please introduce yourself and share some details about your years of practice and trial works? Susan, we're starting with you.
Okay. So this is my 20th year of practice. I began at a large firm in 2001, and I was with Brownstein, Hyatt Farber, Schreck for 13 years before starting my small firm that Laura Hazen and I have had for well, since the beginning of 2014, so we're at 7 years.
Wow.
And I started out in general commercial litigation and then began a specialty in employment law.
Great. Steve, how about you?
I have been licensed since the 80s, but I started doing trial work intensely in around 1992. And prior to that time, I had worked at the Teamsters Union in DC and the Teachers Union here in Colorado and at a law firm in DC. So I started out on my own in 91 and I've had a few detours. Almost everything I've done is employment law, and that includes federal and state courts and all these administrative agencies and arbitrations. And I've practiced in basically here in the DC area. For 4 years, I was in Birmingham, Alabama, and I worked for the EEOC in Alabama, in northern Florida, and Mississippi. So that's what I've done, and I don't think I've had a case for years that didn't involve some aspect of work.
Great. How about you, David?
David Sesserman, currently a sole practitioner for been practicing law now for 37 years. The entire time as a trial attorney. The first 20 years of my practice were at a major Denver law firm until that firm dissolved in 2005. Since then, I have practiced either as a solo practitioner or within several different smaller law firms. Most of my practice is employment HR related, whether it's wrongful discharge or ERISA. And the rest is really all over the place, core commercial work, ranging from just your breach of contract business dispute to intellectual property matters. I think the reason I'm on this panel is a lot of the work I do is with larger firms where I am co-counseling or opposing counsel.
Great. Well, let's jump into it. It can be intimidating as a solo practitioner or member of a small firm in any practice area when you find yourself arguing against big firms. Can you guys each describe a memorable case when looking from the outside? It might have seemed like a David versus Goliath scenario. Susan, let's start with you. I know you've had some recent ones.
So I have to start with the premise, and I know at least one will agree with me, David, that actually it's exhilarating. That it's exhilarating as a small firm attorney to go against the big guys and the big gals. So it's when you love trial work the way I think all of us do here, it's really an amazing opportunity to work your craft. I had a case recently where I was going up against the big firm that I came up under, and there was a lot of press in the case. It was just me and my client, who didn't really have a name in the community, and we were being sued by someone who had a big name, being represented by a big firm. And I would imagine that that's very much how it looked from the outside. And the thing I love the most is really just keeping my head down and working the case. And I think really got a result that stymied the big firm. And so, you know, it's not something to run away from. I'm not someone who engages the press when I try cases or defend cases. I don't believe in using the press in any way. So it may have looked like we were being the David, the quiet David that no one suspected. But in being silent in the press, we were able to go in and me and my client do what we needed to.
Great. Nice. David, how about you?
I agree with Susan. I disagree with the fundamental premise that there's anything intimidating about going up against a large law firm. You know, even large law firms tend to have 3, maybe 4 attorneys assigned to a case. So you're dealing with a small subset of that firm. There are times they will throw the resources to outbrief you or something like that, but really all it requires is a little better organization on your part sometimes. But you need to bring that same organization really to any case. It's just, there are times when, as my friends at big law firms like to say, they want to play big law firm. And you have to understand what that means and how that's used as a verb and as a trial tactic, whether it's dumping discovery on you, dumping discovery in an unorganized fashion, sequentially timing out various motions on the eve of trial to try to interrupt your trial preparation. But it's you know, it's fun. I mean, and you know, in terms of experiences, I don't know. I mean, I've got probably most of my cases over the years have been against larger firms. Trying to think through, you know, right now I've got, you know, I have cases right now. I am, for my client, I'm the client, but or the lawyer, but then again, sometimes I will co-counsel. But you know, go up against international firms. But it's not that different, except that you really have to think certain things through a bit more, such as how are you going to handle discovery? Is e-discovery going to come up? If so, really get in early and often on how you're going to handle it, because you know, big firms tend to be a bit more educated on how they can make it difficult on you, because they may have an e-discovery partner within the firm. And so you may want to, you know, come to an agreement early on about how documents are going to be produced, for instance, rather than waiting for 100,000 single page PDFs to be produced to you. Steve?
Yes, I agree with everyone. The beneficial experience that I've had against big firms in Denver, I was much younger, and I tend to think that my first experience was with Judge Kerrigan. And I can mention the firm, it doesn't exist, HRO. And then another one was Baker and Hospital. And the one, I think it's great when you're practicing by yourself, because you can make the decisions. And I think from the beginning, you have to focus your case in a very narrow, precise way. And to bring the claims that are meaningful, not anything on the fringe, and always be ahead of the game, you know, like be the best student in the class. That sounds corny, but everything needs to be efficient, effective, and targeted. And what I think with the large firms that have a lot of resources, they can sometimes, if you don't have enough confidence, they can cause you to go down rabbit holes or go chasing facts or legal issues that at the end of the day are not going to be determinative. And so I agree. I think it's great. I think it's fun, and I think it's a tremendous test. And virtually all my cases, there are more humans on the other side, more attorneys. And the objective, I think, from day one should be obviously, can we get past summary judgment? And if we get past summary judgment, we're going to have a trial. And when we have a trial, this is my 2 cents, is to present the case in the most narrow, focused, efficient way. Have the jury like you. You're not wasting their time. You're not going on with crazy arguments or all of those things. You're serious, you're there, and your case is tight.
You know, when we talked about putting on this presentation, I was really excited. I kept thinking back to the movie, The Rainmaker, based on the John Grisham book, with Matt Damon against John Voight, and Matt Damon and it's Tony, the guy from Taxi. Can't remember his name.
Oh, yeah.
Tony DeVito or Danny DeVito was
Danny DeVito
was his
and
associate
John
who hadn't passed the bar yet.
Yeah.
Anyway, I thought of that. I always think of that scenario where they're sitting at the table and you have Matt Damon and Danny DeVito and John Voight and a host of others. And there, you know, every litigation movie is like that. It's always the David versus the Goliath. It's Philadelphia, or it's The Verdict. You know, all the great movie lawyer trial room movies have that David versus Goliath, and that's why I love seeing each of you have such really high-end practices that you really are dealing with large firms on the other side and really going into it with confidence. But how do you attract a client who might be facing a Brownstein or Brian Cave, the successor to HRO? You know, how do you convince that client as a solo practitioner or small firm practitioner that you can take on those folks?
Well, go ahead, Susan.
I'll say a few things. I think it's important to really have an upfront, honest conversation with your client and say, you know, this is what we're facing. You've got me and my team, and it's important. It's very important to know beforehand who your team is. While we might be small firms or solos here in this particular presentation, what I mean by team is, frankly, others like us who are willing to work on a contract basis with other attorneys, because I think that's very helpful to have folks in your back pocket. I've done that on several big cases I've had, one of them which was a class action that I was defending. And I think it's important to let your client know that you have the important resources that are needed. Third-party electronic discovery vendors with whom you have a strong relationship, right? You have paralegals that you work with and trust, and other contract attorneys. I think that's helpful. But at the end of the day, it's really about your skill and your brain. And that's something that, you know, once we talk with the clients and explain the approach and how I actually view it to be a huge benefit to be a small firm or a solo, because you will know your case inside and out. You will know the documents in the case, and you won't have a scenario where a few different people have been given siloed tasks to do in the case, and you, as the analogous, you know, big firm partner, might not know all of those pieces and know how to really coherently try a case. And so I think that having those conversations with the client and leveraging the client's own understanding of the facts, really bring them into the process, is something that has worked for me.
Steve?
Yes, to piggyback on what Susan said, I used to describe this as being a lung, that it could expand or contract. So more people may get involved as conducting research or the electronic discovery part, and there may be a lot of players, but at the end, we're all going to come together. And I think it's so important in terms of attracting the client. I think I get clients because somebody needs a certain thing, certain issue, and I can provide it to them. I'm certainly not the only one. And I think, so that would be the issue on attracting clients. The other point I think that's important is there must be enormous client control and client trust. And obviously that's easier with one person. I had a case years ago where I represented virtually every faculty member at Metro State College. And that didn't turn out well, because it's just client control, and having a trusting, efficient relationship is critical if you're going to go the distance against these firms. And when these firms start pursuing areas in deposition and discovery, your client naturally may be worried, like, why is that important? Do they know something you don't know? And so the issue of trust and the ability to expand and contract your services, I think, are important.
So,
How about you, David?
well, to address some of the issues you raised, first of all, how do you attract the big Fortune 50 or Fortune 100 client? And the answer is, for me, it would depend on a personal referral. I do not go out and try to market saying, dear Fortune 100 company, hire me for all of your litigation. I'm not what they're looking for. And similarly, when a large company is sued, let's say they're based in Chicago and the lawsuit is in Colorado, they have no connection here. The junior attorney in that pecking order within the firm in-house counsel, the associate assistant vice general counsel 3 times removed, she's going to look to hire a big firm, probably, because her job is not at risk. And so my colleagues at a lot of the larger firms, they get a lot of business that way. They are one of the largest 5 firms in Denver. And so they're going to get a lot of work that way, because that associate assistant vice counsel doesn't risk her job by hiring a large firm. If she hires me, she's got to be able to justify that hire. Now, it may be she has a relationship with me. And so we've worked together before. And so there's a personal level of referral, and that allows that justification. So in terms of those kinds of clients, the large ones, it's dependent upon some level of, if you will, networking. In terms of how do you handle it in terms of personnel, a short plug to LawBank. One of the ways that I handle larger cases at times is to affiliate with other lawyers. At LawBank, there are other colleagues. There are 3 lawyers on this call or on this video conference right now, all of whom practice employment law. So if there is a large Fair Labor Standards Act defense case that comes in and I'm busy on something else, I can turn to Steve, I can turn to Susan and say, what kind of an affiliation arrangements can we come up with? And I do that all the time. And that is, again, sometimes it is you work through me. Sometimes it is we're going to work as co-counsel. It just depends on the needs of the case and the desires of the client, as well as the other lawyers. But, to me, one of the big advantages of being a tenant of LawBank or a member of the LawBank community is the ability to affiliate with other lawyers, whether it is just stopping by somebody's office and saying, hey, can I have 10 minutes of your time to run something by you? Maybe it's have you ever appeared in front of this judge before? Can you give me an idea of what she is like? Because I just don't know her from a hole in a wall, and I used to be her partner. And so it's taking advantage of that. So by being a member of this community, that is the LawBank community, I'm able to draw on those resources to better serve clients and to more efficiently provide services. Jay, I'll send you a bill.
Thanks. I want to follow up on something you said, Steve, about your Metro case. You know, what tips can you give to clients that may be intimidated or stressed out when they realize they're up against a giant firm, and how you can build trust amongst a group like that versus or even just an individual client? How do you build up trust in your clients when they're seeing the numbers on the other side?
Well, I think you have to be I think you have to be honest, and maybe this talk would be better at a young lawyers division or something. But the first jury trial that I tried all by myself when I was a lead counsel was in New Mexico, in Albuquerque, in federal court against the Farmington Municipal School District. The lead counsel for the Farmington Municipal School District, he and the judge had graduated in the same class at the University of New Mexico, and there were 50 students in their graduating class. And I thought that I was fooling everyone in that courtroom by looking like I knew what I was doing, and I did not. And it was a lesson that, you know, if X bad happened in that case, where my client's looking at a bunch of documents, that's never going to happen in my lifetime again. I mean, it was searing. So in terms of gaining trust with clients, you have to be honest. I think, you know, if again, I go back to the younger lawyer, they will trust. You have to tell them what you've done, you know, what you've learned from the past, be honest with them about their case. Goodness gracious, do not oversell the case. We're going to get you $1 million. That's not going to happen. And another tip to LawBank, Tom Mitchner and I, he's here. We're basically co-counsel on everything we do together, and we've had success, and it's been a great process. So I appreciate that, Jay. And so I think being honest, being trustworthy, communicating with them, letting them know about, because the clients I have are probably, there's no corporation, there's no Fortune 100. Virtually, I would say 80% of who I represent have never been in a lawsuit before, except maybe a bankruptcy or divorce, so or custody. So that they just want to feel comfortable that you know what you're doing and that you're being honest with them. And this is sort of since everyone does employment law, what I've seen over the time is you'll have a witness, you'll have someone on the other side. Hypothetically, let's say someone in human relations at the Denver Public Schools, and they dress right and they act right, and they've got all the demeanor of a business person. You know, I just have the right stuff. I don't get in trouble. And lo and behold, something bad happens to them and they come over and hire someone like me. So anyone can be in the situation of having to file a lawsuit to vindicate their rights.
Can I jump in one more?
Sorry, I muted myself. Tell me, Susan, what you do to help build confidence.
A lot of times I do a fair amount of defense work. So a lot of times I am representing the companies in employment law cases. And, you know, a number of my clients are smaller businesses Not all of them, but some of them are smaller businesses. Some of them are sole proprietors, and they feel like this is the worst thing, understandably, that's ever happened to them. Most of the time, they have never been sued before. Their company has never been sued. They have never been in a scenario like this. And it's important to understand what kind of client you're dealing with. Are they someone who really wants to, have their finger on the pulse of all of the things you're doing? And if so, then to build that trust and that honesty, to follow up on what Stephen was saying, I explained to them, okay, here's the strategy. Here's what I'm going to be doing in this deposition. And you'll see me do this. And they start to recognize elements of strategy that aren't so obvious. And then they go, oh yeah, okay, we can do this. And so I think communication is really key. There are some clients who just say, hey, nope, that's yours, you go do it, report to me on the big matters. So part of it is, of course, understanding the type of client that you have. And I think that I've had several scenarios where I've been in trial and a big firm opposing me, because I do sometimes represent individuals, has tried to, in the middle of trial, pull some unfortunate, what I call sort of stunts, to try to throw me off my game, or to, give the judge a certain impression of me, which isn't accurate. And a lot of times they're discovery allegations. Someone's thrown a discovery allegation at me. And the thing that has, in all of these scenarios, I go very, very, I don't get big and respond in the same way opposing counsel is. And frankly, I think it's really important. I have several of the very key discovery cases in Colorado memorized, frankly. and I quote them, and I ask the judge to handle it immediately. And in some cases say, Your Honor, I need these comments to just stop. They're not accurate. And I've had one judge say in the middle of trial, that's right, there isn't a discovery violation here, let's move on. And so I think you need to have the confidence in your own skill. And to follow up on what David said, a lot of times the other firm will try and take you down a bunch of rabbit holes, and you'll come over here, and this has happened to me, and you show up at trial and they have an entirely different theory of the case. And unless you have paid attention to your own case, that might completely knock you off your rocker. But really knowing that you have everything that they do in terms of your own skill, I think is really key. I ended up somewhere other than the question, but there you go.
Oh, great.
One is Steve said, I mean, what we're talking about now is applicable to not just small firm lawyers, but to any. And if we were given a presentation to our colleagues who just passed the bar and say, what's really important, we'd probably be talking about these same things. But to me, all three of us talked about communication, or I guess I'm the third, but communication is critical to client working relationships, not just management, but how do I as a sole practitioner compete with a larger firm? I communicate with my client, and I mean me. I don't, where do I blow away a larger firm? The client calls me, I call the client. I answer my phone. It's not this, or it goes to voicemail and I call the client back. The client doesn't call my secretary and say, I would like to schedule a call with Mr. Sesserman to get an update on my case, and then gets a call back from the paralegal who says, well, Mr. Sesserman doesn't really want to handle that communication. Can you please talk to the junior associate on the case? So that's where I blow away, quite frankly, a small firm. It's me. I know what's going on. As Susan said, I know every document in the case. I'm not dependent on others. And so, we can have very high level communications, but communicate the living daylights out of the case. That means you deliver good news, you deliver bad news. We're going to have rulings we disagree with, but the client won't be happy with. Sometimes it's a loss in a case. Sometimes it's a motion. Sometimes who knows what it can be. Communicate, pick up the phone and call. Sit down. I just got some news. Now, if the client knows me, sit down doesn't necessarily mean it's bad news. It may be good news. But it is, here's what happened. This just happened. I wanted to send you a copy of this order. I haven't had a chance to read it yet. I will read it. I'm going to do that now, but I wanted you to know right away what just occurred. So anything, expectations we talked about. Manage expectations, set them realistic. Be, and this is the third one, honest. Be honest with your client. Be honest about your capabilities. Be honest with your when something good happens, when something bad happens, when you need to bring in co-counsel or associated counsel. And in terms of expectations, I know in general, I explain to prospective clients right away that, look, I'm a sole practitioner. When I am working on your case, I am working on your case. I don't multitask. If I'm in a deposition defending your case, I am not on my cell phone texting messages to other clients. I'm working for you. Please understand that's going to create frustrations, because there may be time. I'm pretty good about calling you back, but it may be that I'm in the middle of a trial and you don't get a call back until the evening, even though you called me at 8:30 in the morning, because I'm going to give that same attention to your case when it needs it that I have to give to my other clients, but you're not my only client. So again, communicate.
Do you, so each of you spoke about the idea of working, co-counseling, contracting.
Yep.
Do you, in your retainer letters or your engagement letters, refer to those potential relationships?
Yes.
I do.
Yes.
Yes.
So each of your clients knows, to your point, David, managing expectations, that you have the ability to bring in co-counsel or contracting attorneys, and that it's going to cost them to do that.
I have the ability to bring in contracting attorneys. I have the ability to bring in affiliated lawyers. I communicate when I do so. I don't have the ability to bring in somebody as co-counsel to enter an appearance unless I talk to my client. That would require a discussion, and then it would be a discussion about how we're going to handle the finances and why this is going to be more efficient or maybe more expensive. But we have to have that conversation.
Great. Yeah, there's definitely a lot of ethical issues that are involved in this. The nice thing I found in Colorado is most of these issues have been addressed by the Ethics Commission and their opinions on a lot of these, and very practical. I find them to be very practical opinions versus, you can't do it. And as long as there's a lot of communication or advance notice to clients, I find our Supreme Court and Ethics Commission and Attorney Regulation Council being very amenable to these kind of contracting, co-counsel, affiliate relationships. Is there anything else that you guys want to add that you think would be beneficial to somebody who might be facing, or either facing an existing pending matter, or trying to persuade a client to hire them, potential client to hire them, to take on a bigger opponent? Anything else that you think our listeners might be interested in knowing? that you found in your practice?
Be cognizant. To me, it's be cognizant of your own limitations, whether that's time commitments. You know, there are times when I just will not take on new clients. I'm sorry, I'm already fully committed. That's life as a sole piece sometimes. That's different than a large firm where I'm feeding 80 other lawyers. And then in terms of a practice, if you run out of time, affiliate. If you are in over your head on a matter, something comes up that you haven't dealt with before, don't be afraid to reach outside of yourself and ask and use others to run things by them. Again, that is to me one of the great advantages of working in a legal co-working space. There are attorneys who have specialty areas. I'm much more of a generalist. And so there may not be, you know, while I handle some IP litigation, I'm not a patent lawyer. That's a different language. And so there are times you want to reach out, whether it's questioning or whether it's bringing in as an affiliated or associated or co-counsel, a patent law firm, because there are unique issues in that area of practice. Same is true of securities. Jay, in your case, real estate. Yes, I have tried real estate cases. I'm not a transactional real estate lawyer. I understand an awful lot, but there's an awful lot I don't. So you got to know enough to say, I need to bring in some level of expertise so that I can understand some of the issues that may come up at trial. I need an education. That's what CLEs are for. That's good.
I would actually say that, sort of point back to you, David. I think that you had some really great advice about pacing when you're a solo going against a big firm, which I think is important. And I'm gonna, you know, talk about your concepts here and jump in. But this idea that a lot of times what happens to us is if we're dealing with a large opponent, they know it's us. Maybe they, you know we've got a contract attorney or two, and they really do plan discovery to oftentimes give a big document dump on the very last day of discovery, or they've got about, 4 motions in limine planned, all drafted by someone else, that hit right about the time you really need to start doing some of your own drafting a trial brief or trial prep. And so the tip I would just pass along is to work some of those key elements in your case earlier, because you will want to expect that the other side is going to try and take advantage of the fact that you look small. But as I like to say, we are small but mighty.
Steve, you look like you want to jump in.
Well, yeah, couple things. When I talk about keeping narrow and focused, I think it's important all the way through. And following up on what Susan said, I think that's also true at the end, because I've seen these cases where I thought they had a water spigot on, where they were just, they were amending their witness list. They were amending their exhibit list, and they knew I was alone, and they're changing things. And at one point, rather than drive myself nuts, I just stopped dealing with them and on those lists. The other thing, though, is there are people, and maybe they're fewer now, but when I've had occasions where you have a partner at a bigger firm, and he or she is a very nice professional. You exchange your cell phones. You talk on the weekends before the trial. Hey, I'm going to admit this. You're going to stipulate to that. What about this? And you, if you pay attention, you're going to find out pretty early whether that's someone that you can trust and whether they're going to be an honest broker. And it makes the practice of law enjoyable when you have someone like that. As I get older, I see fewer of these people because everyone's younger than I am now. But that is and I try to do that as I get close to trial or anything of that nature, and it just makes life easier. But everyone is not like that. And Susan's point about the multiple motions in limine, that's not only are there multiple, but they're it's beyond comprehension sometimes in the teams.
Great. Well, listen, I want to thank you all for attending today and presenting. And I really appreciate all your wisdom. I appreciate your friendship, and hope that all your cases go your way. Create some new statement out of Game of Thrones. May all cases go your way.
There you go.
Thank you, Jay. You look very distinguished.
Thank you.
Thank you.
Thanks all.
Take care.
Bye-bye.
Take care, everyone.
Thanks.
Bye-bye.